And Ms. Arnold.
Thank you. Thanks for this question as well. What I would think that would make a bad judge, three factors. One is not applying the law as written. Under the law, we have this rule that mistake of fact is a defense, but mistake of law is not. If they don't apply the law as written, then how are we knowing what we're supposed to be doing? A second quality that makes a judge a bad judge is when their pride or their abuse of power gets in the way. They are not willing to review the information in front of them because they don't want to be either challenged or they're afraid of looking stupid, so they make a rash decision, understanding that they have the ability to make that decision. And the third bad quality is when a judge punts. And what I mean by that is, by the time we get to court, it's usually because we have exhausted all avenues of settlement. And if a judge does not help us make that decision, then we are left with nothing else. Thank you.
Thank you very much. The next question will be asked of Ms. Burchell, Mr. Jude, and Ms. Brosnahan. And this question, does it matter whether or not a judge is a person of faith, that would be any faith, and does or should their faith affect their decision making? Ms. Burchell.
I'm not so sure that it entirely matters whether they are a person of faith. For me, faith is extremely important. I have friends who would probably be more agnostic, and I see them to be very good and caring people. But I do think that if you are a person of faith, you're going to bring that into the workplace. I don't know how you can't. I don't know how anyone can separate their faith from what they do and how they make decisions. I think it's an integral part of who you are. If you have a strong faith in God, a religion that you believe in and that you profess, then I think there's no way that you can not carry it into the workplace.
Mr. Jude.
Well, I'd like to thank you for the question. It's a question that I think is very, very personal to everyone here, but it also has constitutional implications in terms of the Establishment Clause that we have in the U.S. Constitution. One of the impressions I have from our court system that I carry with me is the picture of Moses receiving the 10 Commandments over the Minnesota Supreme Court. If you go to the state capitol, you'll see that over the Supreme Court bench. That does not violate the Establishment Clause. I think each one of us carries our principles that we grew up with, that we reflect on. I certainly would ask, I believe, for divine guidance as a judge and reflect on the facts, apply the law and the Constitution as it's written. Thank you.
And Ms. Brosnahan.
Could you just repeat the second portion of the question?
I'll read the whole thing. Does it matter whether or not a judge is a person of faith, and does or should their faith affect their decision making?
I don't think my judicial philosophy is that it should not matter whether a judge is a person of faith, so long as they are capable of reading the law and applying that law to the set of facts before them for a district court judge. And certainly because of the constitutional mandate of separation of church and state, it's imperative that our jurists, whether at the district court or at the Supreme Court, not bring their faith into their judicial opinions. It is a fundamental principle that we have checks and balances in our country, and if we are going to interject personal beliefs into the judiciary, then we may as well not have the judiciary being the overseer of the two other branches of government.
Thank you very much. The next question will be addressed to Mr. Stebbins, Ms. McEnroe, and Mr. Hawley. And this question is, both sides of the political aisle worry about judicial activism. As a judge, how will you address these concerns? Mr. Stebbins.
Judicial activism. Judicial activism, I think in most people's opinions, is this, rhetorically saying legislating from the bench. That's what everybody knows it as now. And there's a whole lot of debate going on these days about legislating from the bench. Well, there's legislating that goes on from the bench by virtue of courts providing precedent in interpreting case law and interpreting statutory law that actually creates law. District court judges don't do that. District court judges shouldn't be legislating from the bench. They shouldn't be listening to either political party or any political party to determine how they interpret the law and apply the law to each particular case. The law as written, as has been said by several people, is provided by the legislature. The judges don't write the law, the judges interpret the law. They read it and they interpret it to the best of their ability and apply it to their particular case. If they go beyond that, yes, then they are typically slapped down by either the Court of Appeals or the Supreme Court.
Ms. McEnroe.
If I were elected, I would address the issue of judicial activism in my own courtroom by diligently applying the law as written, whether that law comes from the Constitution, a statute, or from precedent, either in the Minnesota Court of Appeals or the Minnesota Supreme Court. The best way to combat judicial activism is to be diligent about researching and applying the existing law. In the absence of precedent or a clear statute, the judge is charged with looking to the public policy behind the statute, the reasonable conduct, the objective reasonable conduct of persons in the community, and doing their best to apply what they believe the law to be to the facts before them and to not go beyond that.
Thank you. Ms. Hawley.
I think we can say all day that we are neutral and impartial, but the reality is that every judge is a person, and we bring to the bench our own experiences, our own faith, and to suggest that you can just set everything at your chamber's door and walk into the bench without taking all those experiences and biases with you, I think is unrealistic. So I think it's extremely important, in order to avoid judicial activism and in order to make sound decisions, to recognize what your biases are and to be very self-aware about your own experiences and how it is that you go about making decisions, so that you can, when you're looking at a set of facts, know that, oh, maybe I'm a little too close to this one. Maybe I need to go get perspective from some other judges. If you're not aware of yourself, you're just going to rule according to your own experiences. So I think that's one important factor in combating judicial activism.
Thank you very much. The last question in this round will be addressed to Mr. Marker and Mr. Hansen. And the question is, when should a judge recuse himself or herself from a case?
Okay, thank you for the question. I think that the judge should recuse him or herself from the case if there are situations with the parties or the case itself that would render a judgment from the judge that he or she cannot sit partially in judgment of a case. I think that's the bottom line measurement. Now, it's imperative that a judge be impartial and sit impartially without owing debts to anyone that comes before the court. But what's critical, I think, is that the public have confidence in the system of justice. And if there are situations where there is either the perception or the reality of partiality, that damages the court system and the system of justice. And I think that's what the measuring stick should be.
Mr. Hansen.